All right. Well, welcome everybody. I'm Dave Summers, Executive Director of the Omaha Bar Association. Thanks for coming today on this semi-warm day of the week. I'm standing in place of Angela Lennon, OBA President, who wasn't able to make the rescheduled event due to a firm retreat. She sends her regrets for not being here. I'd like to recognize the members of the judiciary in attendance, if that's possible. We have retired Judge Randall here, Judge Irwin as well. I didn't see Judge Roster. He was on Judge Roster in waiting right here. Judge Hanson, did she make it? She's on our leadership, and she said she was going to be here. Thank you to you two judges for being here. How did we get here? Well, back 35 years ago, we started lunches with Fenner. They were actually breakfasts at the time. It's breakfasts or we did all these events at lunch with Fenner over the years, 30 of them in total, leading up to February 2020. Professor Fenner is no longer doing those events anymore, and there was an interesting. Let's bring this back. Let's talk about this conversation. We wanted to do a cold event time of year when nothing else is going on for the most part. Check. We wanted to have it be a lunch or a meal event. Check. And we wanted to have a speaker that really dug into a deep concept, hopefully constitutionally related in some way. Check. And then Kathleen Pallison, who's our president-elect, who loves UNL College of Law, everything. I was very excited when we talked about maybe having Daniel come and be our speaker. So we're very excited for that. Kathleen sends her regrets. She's at the county court judicial nominations that are happening today. And that's for Judge Marcuso's seat. Those who are looking for something to do next Thursday, Judge Bowie's seat, the interviews for that judgeship for district court, courtroom 316, 10 a.m. It's actually pretty fascinating to watch the public interviews of the candidates for judiciary. On a different note, Steve Morris, right there in the back, retired attorney, he asked me last week when the samples would be distributed for today's talk. And Steve, sorry, we don't have any doctors in attendance. So we'll work with the Metro Omaha Medical Society at our medical legal dinner on the 14th of May. So if you haven't signed up for the medical legal dinner on the 14th of May at Happy Hollow, there's a good reason too. We're turning 150 years old this year as a bar association. Yeah, back in 1875. Yeah. How the years fly by. We're doing some big things for this year. A book. We're working with the Daily Record to put their archives online and have it be searchable by anybody in the public. And those processes are working our way through. We have a lot of sponsors that are supporting us in this endeavor, and I need to thank them. Our Founder Circle sponsor, Daryl Heyman, Heritage Heroes, Coley Jessen, our gold level sponsors of Great Plains Reporting and the University of College of Law, or University of Nebraska College of Law. Our silver level sponsors include Mike Kinney, Mueller Roback, McGill Law, McGill Gottsteiner Law, Dvorak Law Group, Croker Huck, and Sarah Kelly Cooper Sewell, Fraser Stryker, The Daily Record, Core Bank, Houghton Bradford Whitted, the Keyline Building, and Slovacek Albers Whalen. So thank you to those who have sponsored us for this 150th celebration. If you want to join the ranks, see me. We're happy to take your money and allow you to support what we're doing in this 150th year. We also have a couple of special events that we're lining up to celebrate. Those will be more in the August, September, October range, but we're really trying to blow it out of the water, so keep your eyes peeled for that. On to Daniel. Daniel Gutman is a lecturer and leads the First Amendment Clinic at the University of Nebraska College of Law. He received his BA from American University in Washington, D.C. He is his JD from University of Nebraska College of Law. He clerked for the Honorable John Gerard of the U.S. District Court of the District of Nebraska. He spent several years in private practice, litigating commercial disputes, constitutional claims, and election law matters. In addition to his work at the Law College, Daniel manages a small law firm and specializes in civil rights and election law. Daniel has presented to the OBA in the past. For those of you who might remember, he was on a panel for our election law, Just the Basics, a few years back, talking about this very issue and where it stood a couple years ago. I'm not sure if it's still valid for CLE credit, but it is in our YouTube archive, so you can find that. As well, he's been game to be on our podcast, the Omaha Bar Association Bar Talk podcast. So if you want to know more about Daniel Gutman after this, go check out the archives of the Bar Talk podcast. I've talked too long. Without further ado, I'm going to turn it over to Daniel Gutman.
Good afternoon, everyone. I have a little bit of a problem, which is I lost my voice. And so it wasn't ideal timing, but Dave said I could not cancel because we already canceled once. So I'm going to give it my best, and feel free to ask questions along the way because that'll give me a break too. I am excited to be here to talk about medical cannabis. I like medical cannabis. I like the issue. But more so, I like ballot initiatives, like direct democracy efforts. As Dave said, I have a small law firm along with Brian Fahey and Kate Madsen and Alex Arkfeld and Sydney Hayes. We have a small law firm that focuses primarily on election law and ballot initiatives. And really, I see that the medical cannabis, the issue of medical cannabis is kind of having two storylines. The first storyline is the initiative process generally. What is the initiative process in Nebraska? What is direct democracy in Nebraska? That is one storyline of the medical cannabis journey. And then the second storyline, of course, is the title of this CLE, a 3-act play. It has been a long journey. We actually have one of the medical cannabis ballot sponsors here, Adam Moorfeld. He can attest to the fact that this has been a long journey to get medical cannabis on the ballot and then to have it passed. So the second storyline that we have here is just the specific journey, the specific route of how medical cannabis got on the ballot in Nebraska. And it really is a kind of a fast, it's easy for me to say because I didn't have to live it, but it's a fascinating story. And lots of twists and turns, lots of court cases, and we'll go through some of those today. So, like I said, I don't think that you can really understand medical cannabis and the initiative journey in Nebraska without zooming out first and understanding a little bit about what ballot measures are generally. What is a ballot measure? Why does Nebraska have ballot measures, ballot initiatives, referendums? I'm sure if you've been to the farmers market, somebody has approached you with a clipboard and asked you to sign, and you've told them that you've signed 100 times. That is all part of the ballot initiative process. And when I think of ballot initiatives, I think of legislative power, right? The legislature in Nebraska deliberates and they enact laws, and the governor signs those laws, and we follow those laws. That is legislative power, right? And we all kind of know, especially as lawyers, about what the legislature is and how the legislature has power and how we're required to abide by that power. I think what's less known is the other branch of legislative power in Nebraska, which actually is the people. So when I go to the farmers markets and see those people with clipboards and they're asking you to sign the petition, it's really in many ways similar to the legislative debate that you see on the floor of our unicameral. I mean, they're engaging in the same process, right? The ultimate goal in the legislature is to get a bill passed. And in order to do that, you have to do certain things first. You have to have debates, and you got to have committee hearings and, whatever else it requires. Well, the same is true for ballot initiatives. in order for the people to exercise their legislative authority, they have to meet certain requirements. And there's this 1970s US Supreme Court case, which I think explains the process well and actually centers where the power is in my mind. And especially this highlighted line in establishing, so under our constitutional assumptions, all power derives from the people who can delegate it to representative instruments which they create. In establishing legislative bodies, the people can reserve to themselves the power to deal directly with matters which might otherwise be assigned to the legislature. The reason why I think that this passage is so empowering is because what it's saying, and it's correct, is that legislative power comes from the people. The legislature does not give us our power. The governor does not give us our power, right? Congress does not give us our power. All legislative power derives initially with the people, who then can decide where that legislative power is enshrined. So in reality, we gave the legislature their power. When you watch the legislative debates, that came from the people. The reason that they're able to do that and the reason that they're able to pass laws is because the people have given some of their legislative power to the legislature. Now, in many states, and about 20, I think it's about evenly divided. In many states, the people, in writing their state constitutions, have given all legislative authority to the legislature. In other words, in order to pass a law in those states, the law has to go through the legislative process, through a legislature, two committees, what we're used to. But in the other 25 states, approximately, including Nebraska, what we have done is that the people have given some legislative power to the legislature, and they have reserved legislative power for themselves. I think that that's really important because, again, it puts the power with the people, right? We gave power to the legislature to legislate, and then we reserve some for ourselves. And that reservation of power is actually explicitly written in the Nebraska Constitution. So Article 3, Section 1 of the Nebraska Constitution, the legislative authority of the state shall be vested in a legislature consisting of one chamber. The people reserve for themselves the power to propose laws and amendments to the Constitution and to enact or reject the same at the polls, independent of the legislature. So again, in Nebraska, what we have done through our Constitution is we have said we are not going to take all of our power and give it to one legislative instrument, the legislature. Instead, what we're going to do is we're going to give some power to the legislature, and we're going to reserve others for ourselves. And, one thing that the Nebraska Supreme Court has said time and time again is that the people, because this is a reservation of power as opposed to a grant of power, again, the legislature didn't grant us this power, we reserved it for ourselves. And because we have done that, the Nebraska Supreme Court has described the people as co-equal branches of the legislature. In other words, the legislature doesn't have more authority to enact laws than the people do. We are co-equal branches. And that's a really important point for ballot initiatives and ballot measures more generally. So just as the people have reserved power for themselves, and just as we have created this process where we can pass laws and constitutional amendments through initiatives, we've also have self-imposed limitations on how we can go about this process. This is not an exhaustive list, but these are explicit constitutional limitations on the ability to pass an initiative. And clue you in for the rest of the talk, these three are all relevant for the medical cannabis initiatives. So Article 3, Section 2 of the Nebraska Constitution, what it says is that the people reserve for themselves the right to pass ballot measures, but they have to meet certain requirements. There is a signature threshold. If you want to enact a statute, 7% of registered voters have to sign a petition. If you want to do a constitutional amendment, 10%, higher threshold. we also have this geographic requirement, which is often referred to as the 38 county rule. And essentially what it says is that you cannot collect your 7 or 10% from high densely populated areas like Omaha and Lincoln. You have to have at least 5% of registered voters from 38 counties in Nebraska. So not only do you have to have a overall requirement of numbers, the number of signatures you have to have, but those signatures have to come from throughout the state. The last requirement is the single subject requirement. This is probably what people are most familiar with in the context of the medical cannabis because of the 2020 decision, which we'll talk about. And the single subject requirement says initiative measures shall contain only one subject. What that means, I have no idea. Okay. So 3-act play. We have 3 different election cycles in which medical cannabis has tried to get on the ballot. And the first starts in 2020. What happens then? A series or a number of people, primarily parents of children who have illnesses that require cannabis, got together and they said, we really want to put this on the ballot. We've tried and tried and tried at the legislature. It's not working. The legislature is blocking our efforts to legalize medical cannabis. So we want to take this to the ballot. So in 2020, I'm going to make sure I'm not giving anything away here. 2020, the petition sponsors and volunteers decided to try for a constitutional amendment. And that's significant for a couple reasons. One, constitutional amendments passed through the people have the higher signature threshold. So it's just harder to get a constitutional amendment on the ballot. The second is kind of an unwritten rule. You're not going to find any case law to this effect necessarily, but I think just generally courts around the country are more skeptical of constitutional amendments. When you want to enshrine something in the Constitution, they just take a closer look. And look, let's be honest, when you want to enshrine medical cannabis in the Constitution in Nebraska, they're definitely going to take a closer look. So that's kind of an unwritten rule, but it's something to consider. So these advocates got together and they pushed in a constitutional initiative to enshrine medical cannabis in the Nebraska Constitution. This was the object statement or the summary of the petition, was to amend the Nebraska Constitution to provide the right to use, possess, access, and safely produce cannabis and cannabis products and materials for serious medical conditions as recommended by a physician or nurse practitioner. The important thing about this initiative, for purposes of the legal challenge that followed, was that everything in this bill, this constitutional amendment, pertained to medical cannabis, but it was expansive, right? It touched not only on a person's right to use and possess, but it also talked about the industry, right? If you give somebody a right to use and possess, you have to create some sort of industry that makes that product available. What the sponsors of this initiative tried to do was encapsulate all of those things in one constitutional amendment. And because of that, it touched on a lot of different areas, all under the umbrella of medical cannabis, but that's basically what invited the challenge. So in 2020, what happened is the campaign did garner enough signatures. They satisfied the 38 county requirement, meaning they got the 5% from 38 counties. They satisfied the 10% threshold, which, by the way, is extremely difficult, especially the 38 county requirement. Extremely difficult, extremely expensive. This is not an easy process, and that's by design. But they satisfied all of those requirements. The Secretary of State said, yep, you're going to make it. You're on the ballot. And right before the ballots were printed, Sheriff Wagner out of Lancaster County filed a lawsuit claiming that the initiative violated the single subject rule, which is the constitutional text that I showed you a few slides ago. the Nebraska Supreme Court, because of how litigation works in this area, things are very rushed. There's not much time for litigation. And so basically, cases are filed directly in the Supreme Court a lot of times, and the Supreme Court issues an opinion sometimes within days of hearing the case. That's what happened here because they needed to get the decision out before ballots were printed. And in a divided court, but the majority held that the constitutional amendment violated the single subject test. And if you read the opinion, it's pretty clear that the court just thought the initiative did too much, right? They distinguished, for example, a person's right to use from an industry's right to manufacture. They saw those as different subjects. We have a question. Patrick.
What's single subject? What is a single subject?
You'd have to pay me a lot of money to answer that question, Patrick. No, I'm kidding. It's text in the Constitution that is relatively conclusory that says initiatives can only contain one subject. That case law has developed, especially over the past 10 years, as we try and figure out what that means. And, frankly, as the court tries to figure out what that means, this is an issue that comes up in a lot of states with initiatives. Actually, the legislature also has a single subject requirement. So legislative bills are also subject to a single subject requirement, although that has tended to be much more deferential. And so it's not hard for the legislature to comply with the single subject rule. So here, the Nebraska Supreme Court, at the very last minute before ballots are printed, after all the signatures are collected, after all the work is done, they say, sorry, this violates the single subject test. We're not putting this on the ballot. This is kind of the conclusion that the Supreme Court reached. So that brings us to Act 2. Kind of undeterred, this group gets back together and decides to try again. Now, I think not relevant legally necessarily, but I think really relevant to the process more generally is, after you're thrown off the ballot the first time, that all the money's spent by the time the Supreme Court weighs in, right? And so it's hard to get funders. And one really admirable thing about this group coming back in 2022 is it was really a primarily volunteer campaign. And to collect the number of signatures that you need from the counties that you need them from, it's an enormous undertaking. But this volunteer group had mobilized, they decided to go again, and they tried with a 2022 petition. Now, real quick here. The 2022 petition was different than the 2020 petition in a couple of ways. One is the 2022 petitions were statutory as opposed to constitutional, which again means a lower signature threshold is required under the Constitution. There's other practical considerations with picking statutory as opposed to constitutional, but the most significant one from a legal perspective is you have a lower signature threshold. The other big difference between 2022 and 2020 was the campaign had to respond to the single subject decision that they had just gotten 2 years before. And the takeaway was, we can't put everything in one petition. We've got to separate them into two. This is also, side note, it's something that casino gaming has done. You probably have maybe signed or encountered somebody at a farmer's market talking about casino gaming. They also got thrown off the ballot 2010-ish. They came back and they had 3 petitions because they wanted to achieve their objective, and they thought that they needed 3, which, by the way, logistically is just very difficult to hold 3 clipboards and walk around and have people sign all 3. I mean, it's hard. So what the group did with the 2022 petitions is they made it statutory and then also separated the issues and had to abandon issues too, right? You can't, like the previous slide, the Supreme Court says we find at least 8 subjects. Well, then we're going to carry 8 clipboards, right? So you got to decide what you want to keep and what you want to leave. And you narrow it down and you break it down into 2 petitions and you circulate these 2 petitions. The Nebraska Medical Patient Protection Act, which this is all very general and would take a lot longer to go into specifics of this, but generally the way to think about the first initiative is that it decriminalized or depenalized the use and possession of limited quantities of medical cannabis. And then the second initiative was the Nebraska Medical Cannabis Regulation Act, which again, very generally sets up a regulatory scheme to allow for distribution. Okay, so they write this language, they file it with the Secretary of State, they go out and collect the signatures, and this is where I started getting involved in the campaigns is in 2022. And we realized that we're not sure if we're going to hit all the thresholds, right? It looks like we're going to get the appropriate number of signatures, the overall threshold requirement, but may not get the 38 county rule. We may not get them from 5% from all 38 counties. And so we file a lawsuit in federal district court challenging the constitutionality of the 38 county rule. And this is also, could take hours to talk about, but very simplified, very boiled down. We weren't writing on a blank slate here, right? We had Supreme Court precedent that talked about this principle that everyone's familiar with of one person, one vote, right? And there had been some Supreme Court case law, and there's some circuit court case law outside of the circuit, 8th Circuit, that talks about this principle of one person, one vote extends to ballot initiatives. It not only applies to voting, but also signing a petition, because that is your access point to voting. And the basic notion is that these geographic requirements put immense amount of power in rural counties. If you are a campaign organizer, the value of a signature in Omaha is much less than the value of a signature in what county? Box Butte County, right? Box Butte County, the signature there is worth so much more because you have to comply with this 38 county requirement. And so what other courts have held, including in Burnback v. Gale, which is a 2014 case that was in front of Judge Battalion, he had already struck down the 38 county rule in that opinion. It went up to the 8th Circuit and it was reversed based on standing. So basically erased any precedential value, but the court had never reached the issue. So what we decided to do is we said we're going to challenge for the 38 county rule, picking off of Burnback versus Gale, and we're going to say, look, this rule gives outsized power to rural counties. Again, it really wasn't that remarkable of a position because lots of courts have talked about that. And again, the reason why is we were reaching the point where signatures needed to be turned in, and this was kind of one way that we thought we could qualify, get rid of an unconstitutional roadblock to qualification. So it was a very immediate response. We get a injunction from the federal district court saying, yes, the 38 county rule is unconstitutional, or they're likely to succeed on the merits. And so the federal district court enjoined enforcement of the 38 county rule, which paved the way towards ballot qualification because we did have the raw number of signatures that we needed. That kind of paved the way in an emergency. Yes, Judge Gerard. So this was now the second federal district court judge in Nebraska that had ruled the 38 county rule unconstitutional. And the state filed an emergency appeal and the 8th Circuit reversed. And basically the rationale of the 8th Circuit, which, drew a dissent, this is kind of it's a complicated issue, is that these kind of procedures are subject to rational basis review as opposed to the heightened review that other district and federal court judges have applied. And so they dropped it down to rational basis, and they said there's a rational basis.
The panel.
Wow. I thought you were supposed to ask me easy questions. I know Judge Kelly was on the panel because she dissented. I cannot. I cannot remember. So Eighth Circuit reverses. That kind of ends the case. The signatures were turned in because I think that there was, a possibility that 38 county rule was satisfied. But because of how it works, a lot of signatures are thrown out. So it's hard to know for sure whether you qualify or not. So signatures were turned in. They ended up not qualifying in 2022. So it wasn't kicked out necessarily on a single subject type challenge. It was kicked out for failure to meet the 38 county rule case or requirement. Okay, the saga continues. Act 3, 2024 petitions. So, for reasons beyond me, this group gets back together and says they want to do it again. So 2024 petitions, they circulate the same two petitions. So the good thing here is you don't have to go back and rewrite the language. You don't have to tailor it to some opinion. You just file the same two petitions that went in 2022, and that's exactly what they did. This time, some of the same, there we go. This time, some of the same issues come up, right? Funding and all these things that every campaign has where you're trying to navigate. How are we going to collect these signatures? How are we going to satisfy the 38 county rule case? How are we going to, deal with all the legal challenges? All those issues come up, but they were able to gather the signatures. Again, same two petitions here, Patient Protection Act and the Medical Cannabis Regulation Act. Same two petitions go out. They are circulated throughout the state. This time, the signatures come back. There's reason to believe that all thresholds are satisfied. All signature and county thresholds are satisfied. The petitions are turned in. And this time, what we have is signature thresholds satisfied, 38 county rule satisfied, single subject requirement satisfied. So we're done, right? Well, that's a whole nother story, but so the takeaway here is that this time all of these things have been satisfied. All of these procedural requirements over the single subject test, for example, have been litigated, I think, and goes on the ballot, passes, governor by 71% or something. Governor signs them into law, and right now these are the law. So where are we at now? I mean, I'm sure that most of you seen I feel like if Adam sneezes wrong, he gets sued. There's lots of litigation around this issue. It's nonstop. That's not really the point of this talk. That's all ongoing. We'll see how that all shapes out. But what is the current state of the law? This is not the entire initiative that went into law. This is just a snippet of it. But again, very generally summarized, the state of the law is that we have a statute on the books that says that people can use and possess limited quantities, all of that is defined, of medical cannabis with the recommendation of a healthcare physician. There's also mechanisms for children suffering from medical conditions who, like the Mayo Clinic and all these groups. A lot of doctors from out of state, parents in Nebraska will send their kids to the Mayo Clinic and their doctors will tell them, look, we think that cannabis is the appropriate response for this particular condition. But of course, parents here cannot give their children cannabis. Now, what this law says is if you comply with the requirements, you can do that. And then on top of it, we have this Regulation Act, which contemplates a regulatory scheme that would allow for the industry component to be regulated through the Liquor Control Commission. It's a very complicated process, and they have not promulgated rules yet. By law, they're required to do it by May. But what we see here is two initiatives working together in order to facilitate medical cannabis in Nebraska. 5 years in the making, many, many legal battles, but we are here, and many more legal battles to come, I'm sure. But that is kind of the short synopsis of the 3-act play. Now, I want to leave time. I want to stop talking for a second, but I also want to leave time for questions. Is that okay, Dave?
Yeah. Can I start first one?
Sure.
I'm a money guy. Can you tell me generally how much money was spent on each side for and against your?
Oh, wow. The loaded question.
I mean, it's the first initiative for 2020.
And don't quote me on this. You go to NXT website, but off memory, I think it was about $2 billion that were raised. He had some major donors. Second one, 2 of our 3 major donors died literally 3 months before St. turned in. One pancreatic cancer, one plane crash, and the other one just couldn't go through an obligation, got the other cheeks, and I think that was around $500,000 or $600,000, but came short signatures. This last one, I did not get the finals this year, but I think it was around $800,000 that we raised. To give you guys an idea of what most campaigns raise for a campaign like that, it's usually around $2 to $3 million. So this very much was a grassroots. There was some paid collection, but very grassroots. And I grandmother campaigns like Casino Gaming Industry, where we had 5 to 6 weight bulbs to the sectors, and we were a little concerned for the ends. I'd had to just ash. So just to give you
You ever look at the other side was spending?
no, because the other side oftentimes it's not exposed what they've spent. And I had to search a video on that. I'll click out in that. But they oftentimes now wait till quarters. Yeah, they wait till they can file a lawsuit and they kind of roll their dice. And particularly with medical marijuana, which is only 70 to 80%, I think the other side didn't see the value in opposing that if the public education.
Other questions? Maggie.
At what point do you come in to all of this in a legal perspective? Like, at what time does a ballot initiative come to you and say, this is what we want to do?
Well, I think so. The question is kind of where does the legal component of a ballot initiative come in? In an ideal world, you'd be involved throughout the whole process, because the way that the process works is you have to draft language for an initiative that you file and go collect signatures on, and that language is what is ultimately challenged. And so if you don't have that support on the front end to be running these traps and figuring out what complies with the single subject rule, what doesn't, then you can lose on the back end. And so ideally it's throughout the entire process, but certainly what we've seen is ballot initiatives getting sued on the back end right before the issue is supposed to be printed on the ballot. That's why you see all these emergency Supreme Court cases right around the election. That's kind of how it all pops up. Yes.
That case not been filed before the ballot, or is it? Like, what would it been the process?
Which case? I'm sorry.
I'm sorry, like Sage 2, where they the ballot was printed, and the ballot was printed or had the vote cut out. There's still a chance to prevent vote.
So the question is what happens if you file a legal challenge? If you don't file it essentially right before the ballots are printed, there is some case law that says that a ballot initiative can be challenged even after the ballots are printed. So there's an old case, for example, where the people, there was an initiated law, it passed, the voters voted for it, and then the Supreme Court, like 2 years later, considered a procedural challenge to the initiative and invalidated the law. So there is some precedent for the fact that a ballot initiative can be challenged. I know Adam and the medical marijuana people don't want to hear this, but there is some precedent that to the point that a ballot initiative can be challenged even after it's on the ballot and even after it passes. And I would say that's similar to the legislature, right? I mean, the legislature can debate a bill, they can pass a bill, the governor can sign it, and then somebody could come later and say, hey, you didn't comply with procedural requirements, even though the law has already passed. So it's kind of an analog. Yes.
When am I going to be able to go out to have a store to buy, while I'm smoking?
The question is, when can he go buy marijuana and smoke it? Well,
Legal. That's right.
I want you to write down these statutes because this is the law right now. As long as you have a recommendation, again, you got to comply with everything that this says. I'm going to say the wrong thing and someone's going to... as long as you comply with the recommendation process for medical cannabis, this is the law right now. Now, the reality is we don't have a regulated industry yet, but other states do.
Yeah, so that would, I guess that's the other part of the question. When would somebody be able to, as a supplier, start legally selling?
Well, what the law contemplates, I mean, this is the law. This is not me up here saying what I want the law to be. What the law is, which 71% of Nebraskans passed, is that starting in May of this year, the Cannabis Commission should be starting to promulgate regulations and issuing licenses, I think by October. Don't quote me on that. But if the law is followed, then there should be regulations in place. There should be licenses issued for medical cannabis. Yes.
Just a quick, but still have fun. But so you mentioned people go to Debji's Bampton and they get the reputation. Let's say that the parent child gets a reputation to the doctor out of state for cannabis. Would they be able to right now bring it into the state and point to this law and say, well, I do have a doctor's certification out of Nebraska about this?
I am hesitant to answer that only because the question was specifics about whether somebody gets a recommendation from a physician for their child out of state, brings it into state, gets medical cannabis. I mean, I'll just speak bluntly about what I think parents are facing, which is we have this law on the books and people are very worried about whether our government's how they're going to react to it. And the reality is when a doctor tells you to give a child medical cannabis, in a lot of other states, that's fine and it happens. Here, there can be drastic consequences, including having your children taken away, if they test positive for cannabis. And that is a real dilemma that a lot of families in Nebraska are facing. I have my own thoughts about what the state of the law is and what the response to that is. I'm hesitant to go into it because it hasn't been litigated and it's a little bit, it remains uncertain. Yes.
I guess, do you believe that the success of people also that's, I guess, you pick it presets or broader stages, broader a criminal it's issue money across the board, like with marijuana, or I'm just curious.
Yeah, so the question is whether the passage of an initiative like this could have impact on broader criminalization of cannabis generally. Is that fair?
Yeah.
Yeah, I don't know. I think what we've seen in other states is, we're like one of the last states to depenalize medical cannabis. This is just a non-issue in most states. And what has happened is some other states have also depenalized recreational. Do I think that Nebraska is going to use this to go to recreational, not anytime soon, frankly. That's just my opinion. But could it happen? Sure. The argument against this campaign is that this is just a stepping stone for recreational. I actually don't think that that's true, because a lot of the families that pushed for this don't really have an interest in recreational. I mean, this really was a largely volunteer effort pushed by families with children who are affected by this issue. Whether it's a stepping stone in other states, that may be true. I actually don't think it is here, but again, that's just my opinion.
Are there any limitations on who can fund such a ballot initiative? And I've kind of up its urban legend. I'm thinking back to when the Nebraska legislature overturned the death penalty, and then there was a ballot initiative. The rumor was I was largely financed by the government. But overall, my question is, people are investing money in a campaign. How to disclosure, who they are, where money's coming from.
Dave, is this recorded or? The question is there limitations on who can fund a ballot initiative? Not really. I mean, I'm sure there are. Funding of ballot initiatives is supposed to be disclosed. So there is a whole Nebraska Accountability Disclosure Act, which requires funding to be disclosed. Are there limitations? I mean, there are some limitations on, giving to political causes generally, but as a general matter, no, there's not many limitations on who can fund a ballot initiative as long as it is disclosed.
Give us the 3-minute primer on federal. We're at case sense federally right now. Comment direct steal.
So the question is, where does it stand federally? That is the source of a current lawsuit right now over federal preemption. Turns out that state rights people like federal preemption sometimes. But it is, well, anyway, it's the subject of a current lawsuit right now. I will say that many, many states have depenalized medical cannabis. Many state Supreme Courts have considered the issue. That has not been a successful argument in most places for many reasons, but we'll see. Yes.
States. Gene up to date with by prescription. The doctor actually prescribe it to match the app temperatures. Or is it just a recommendation that they have?
So the question is in other states, do they require like a prescription or how does it work? I actually don't know. I know that some states require like medical cards. Some states require prescriptions. I don't know the answer to how other states have done it really. I know that under this regime, you do have to have a written recommendation from a medical professional. That also does bring up another issue, which I think is really important in the ballot initiative context. Like I said earlier, the Nebraska Supreme Court has held time and time again that the people are co-equal with the legislature. And there is language in our Constitution as legislative actors, right? There is language in our state constitution that talks about once the people pass something like this, what can the legislature do to, tack on to it, potentially undermine it? And that's a hard process, right? The Constitution specifically contemplates a process that makes it very difficult for the legislature to react to the people's will by undermining it. And the reason why I bring that up is in some states, I think what has happened is the legislature hasn't liked what the people have passed. And so they try and make things more stringent. So this says medical recommendation. Well, no, now we want it to say a prescription by a doctor who lives in Box Butte County. And that's the only person that can ever write a prescription, right? Like the legislature can't do that. Yes.
The pending lawsuit, AFM happening before this is supposed to start May.
Of the pending lawsuits, do I see any of them being resolved before May? I honestly don't know the answer to that. I mean, there is a pending lawsuit. There's a pending lawsuit appeal in the Supreme Court as well. When they will be, I mean, I have an idea of when they'll be heard, which is over the next few months, but the timing of when they'll be resolved and how it will impact things is a little unclear. Yes.
To the question earlier, when can I go and get my recommendation? Do all that. What they should do is the legislature right now, there's 300 proposals that have legs. All of them move back the regulation timeline, formulation of the regulations to October 1st instead of May 1st. And then they'll start hitting licenses in January 1st based on drafts that will be for March 3rd. Well, hold up. We're committee. So I'll just, and Nebraskans for medical marijuana is not opposing that because we were told by the future regulators that they would need more time to promulgate and issue those licenses. And so just, even if Nebraskans for medical marijuana is successful at defending itself against the lawsuits, you're likely not going to see licenses issued until January 1st. That it's not the immaculate conception, so they have to actually grow it. Create facilities have to be at the licensing, grow it. So you're really not looking at this being available in state until 2026. Just FYI.
So it could be up the
Some Missouri. Yeah, in theory, based on the current legislation, that's general has consensus in terms of what's.
Okay, I think we have time for one more.
I was looking into the post-permission for licensing. It looks like the application is somewhere to $100,000, I believe. But is let's say we would take your $50,000 application and would say, sorry, we'll license for you, get your money back. So in one pieces of that legislation, do you get a portion of your money back? Well, sure. Yep. And another, which is normal in most states. That's how it works in most states. In some states, you don't get any of them. So, I could have to read the legislation. I think it's 2/3 or something like that.
2/3, so it's potentially a $33,000 BM to see if our meters grant you a license.
Yeah, you have to have millions of dollars to successfully create a vertical grow rig. So if you don't have $33,000, you're throwbacking business fee. Keep your data. That's too bad. Like, couples of dollars, days. Well, so you can see that under the first legislation. It's Sunday Matthew for upload. I think we've taken over the.
No, hey, okay. I don't know the answer to those questions. Anyway, thank you. Happy to answer any questions afterwards, too. Hold on.
Oh. Yeah. You know, we tried to make sure that this is on April 20th, but that's a Sunday, Easter Sunday. So we moved it up a bit. I love the questions and the conversation. This is actually in a series. We had Secretary Ebnen as our speaker for Law Day last year, for those of you who remember. We had Dr. Matt Garlinghouse from UNMC, who works in medical marijuana at UNMC for kids that have seizures and things like that. So we've been on this conversation for a while here and see how far we've come. Thank you, everybody. Please sign in for CLE credit. And our next event is Ben Nelson on March 4th at UNO's Thompson Center. So check that out. Thanks.